Ben Wizner is the director of the ACLU's Speech, Privacy and Technology project. For nearly 2 decades, he's litigated cases at the intersection of human rights and national security. And since 2013, he's been the principal legal advisor to the NSA whistleblower Edward Snowden. Join him now in conversation with award-winning investigative journalist Nick Davies as he discusses whistleblowing, press freedom, and more.
Okay, so Ben, what you and I have in common is Edward Snowden. Mm-hmm. And just to explain, my involvement with him was that I was called into the Guardian office in London to deal with that part of his disclosure, which covered the British Interception Agency, GCHQ. And we worked in a secret room there under a great deal of legal and political pressure and managed to publish a series of half a dozen quite significant stories, and we might come into the detail of it. But essentially, it was about GCHQ assisting the American National Security Agency in the bulk collection of our communications, whether through the internet or telephone calls. So that was in June 2013. So that, in short, is how I come to be involved. If I now pitch it to you and you explain how you came to be involved and what your role is.
Yes. Thanks, Nick. What a pleasure to talk to you about this. I came into this because of my long association with Laura Poitras and Glenn Greenwald, who were the original 2 journalists to receive the archive from Snowden. And so I was alerted as far back as January of 2013 that Laura Poitras had received a mysterious communication from someone who signed himself Citizen 4 that either could have been an announcement of one of the more significant disclosures in the history of America, or a crazy person, or some kind of entrapment. And Laura was seeking my advice to try to figure out how to proceed. And of course, in your profession and in mine, one thing we have very much in common is that we probably often get communications from people who insist that they're the most important whistleblower in history. And sifting through those can be quite challenging. This one seemed to me credible. My advice to Laura was to make sure that she didn't approach this as an independent journalist or filmmaker, but that she tried to bring in some news organization that would have more legal and institutional protection. She eventually chose Bart Gellman and the Washington Post to play that role. But I didn't learn Snowden's name until the whole world did in early June of 2013, when that video was posted to your paper, to The Guardian, where he announced himself sheepishly to the world. And I didn't connect with him directly until about a month later in July of 2013, when Laura and Glenn put us in touch with each other. At that time, he was still in no man's land in Sheremetyevo Airport. They realized that he needed to have a lawyer who looked out only for his interests. And that's when I became his legal advisor.
Okay, because we could look at the issues here roughly under 2 headings. One is publication, what obstacles there are to that, legal, political, or other. And then there's Ed Snowden himself surviving as a whistleblower. And if that makes sense, would you talk for a moment about what legal or political difficulties there seem to you to be in the way of publishing Ed's material in the United States? And it may be there weren't very many, but...
Well, it's certainly not the same as the UK, where we had that extraordinary spectacle of, I take it they were GCHQ agents who came into The Guardian to preside over the meaningless destruction.
Yeah, I'll tell you about that in a minute. But if you give me the American end, I'll come to
I hope so. Yeah.
Okay.
On the other hand, I don't think it's fair to say that there were no obstacles in the US. Remember, if you've read Bart Gellman's book, which was recently published, and I recommend it to you, he describes approaching the Washington Post and their publisher and their lawyers and being advised by their lawyers not to go to Hong Kong. There had never been a leak of this kind of signals intelligence material before, let alone at this scale in the United States. And the concern of the Washington Post lawyers was that given the broad scope of the U.S. Espionage Act, which criminalizes providing to people who are not authorized to receive it any national defense information. And we can come back to that.
Mm-hmm.
It's just going to China and Hong Kong being within China's ambit, where they might be under surveillance from the Chinese government, and engaging in these conversations might bring the reporters within the ambit of the Espionage Act, even though there has never been until, and we'll talk about this later, the Assange indictment. Yeah. There has never been a prosecution of a journalist in the United States under the Espionage Act. Generally, and this is a combination of law and tradition, the rule in the US has been, if you're the source and you have a contract and confidential relationship with the US government, you're very much on the hook for what you give to journalists. But we've drawn the line, until recently, a very, very firm line against including journalists, against prosecuting the publication of truthful information lawfully received. And so I had some confidence in 2013 that so long as these publications were done by news organizations and not on somebody's blog, but done in The Guardian, done in the Washington Post, that there wouldn't be legal consequences for the journalists, although the journalists themselves were quite nervous and didn't travel to the US for over a year after the publications began because they didn't know what would happen. Yeah. But we don't have an Official Secrets Act. And again, until the last year, there had never been in the history of our Espionage Act a criminal case brought against journalists or publishers.
Can I just ask whether, separately from the question of journalists being punished, prosecuted, is there the capacity within the US courts for publication to be blocked? So the government would go to court and say, we hear the Washington Post are going to publish this. Let's get a court order to prevent that happening.
So this, of course, was the subject of one of the landmark First Amendment cases in US jurisprudence. It involved the New York Times and Washington Post and others publishing the Pentagon Papers in the early 1970s. And the Nixon administration did, in fact, go to court to secure an injunction against the New York Times, against the publication. That case made its way all the way to the US Supreme Court, which decided, in a somewhat confusing decision, but decided emphatically that there could not be a prior restraint against publication in those circumstances. Now, it did actually leave open the door to prosecution, which again has never happened before. So that is not settled within our jurisprudence, but the prior restraint is very, very difficult to obtain.
So just to pick up on the UK, and as you suggested, the position here is primitive and crude. First of all, in the background, I can hear a slight echo. I hope that's not interfering. In the background, we have a culture of official secrecy, so that generally speaking, anybody who's working in any role in government doesn't talk to the press. And when I worked in Washington, D.C. for a couple of years in the late 80s, I was amazed to be able to phone people up on the basic assumption that they wouldn't mind talking to me. It's utterly different. And then we have the law. So what happened in this case was that we had all this material about GCHQ. The Guardian editor got legal advice from a specialist, a good guy who's not frightened. And he said, you're in trouble. At any moment now, the police can come into the building, arrest anybody who's handled the material, seize computers, and you all go to jail. And B, if they want to, they can also go to court and mutter the two words national security, and there will be a court order forbidding publication. And if you breach that, you're in contempt of court. And the penalties for that are without limit. They could fine you, let's say, £1 million a day for every day you defy the order. You can kill the paper. So it's interesting how different it is. And you know, there have been these occasions when English newspapers have reached out to American ones to try to get shelter under the First Amendment because our law is so primitive. And just very briefly, in this case, our approach, which is often useful in this country, is to look at a legal problem as being really a political one in disguise, that the law is administered by people who are politically aware. And so we set out to send signals to affect the political judgment that was being made by the government as to whether or not they really wanted to send police officers into this newspaper office, or did they really want to go to court and get into this sort of fight? And essentially we were saying, look, we're not crazy. We're really not going to do something that helps the terrorists to attack London. So just relax and back off. And they did back off just long enough for us to get the material out.
And then I understand that there was a transfer of the material also to Guardian USA and to the New York Times, so that by the time they did have their really pathetic tantrum, that display, childish display, it was moot because the material was already elsewhere.
Yeah, so we managed to keep them out, I can't remember, for about 4 or 6 weeks, and published important stories from that material. And then there came a point when the government ran out of patience. And so they said, all right, you've had your fun. It's all over. And so, yes, the editor arranged for all of the material to be sent to the US, to the New York Times, so that they could then come in and engage in this weird pantomime of physically destroying these laptops. And we never really understood what they thought they were achieving. It may have been that they were trying to send a message to the US security and intelligence agencies that they were taking it all seriously, or they were trying to send a message to GCHQ staff that we're protecting your security or whatever.
Well, I think actually, and this is one thing that our governments have in common, is that so much of what the discourse of secrecy is really about is control. So it ends up being a kind of theater. In the US, the intelligence community cares much more about their authority to decide what's secret and what's not secret than they do about any particular secret. And the reason for that is that when civil society organizations like the ACLU try to bring constitutional challenges to their actions, so long as they're able to say to a court, this activity is clandestine, it's formally secret, it's never been acknowledged, even if the facts are out there, the fact that they haven't acknowledged it allows them to get these cases dismissed and to preserve their impunity from any kind of accountability. And so, I tried for years to litigate cases against the security state over the Bush administration's torture regime, to litigate these cases on public facts and public evidence, but the courts would always yield to the assertion of state secrecy on the ground that it had not been officially acknowledged. And so that's why you end up having those kinds of silly. Let me tell you one story that is sort of similar to your laptop destruction story at The Guardian. When you all, The Guardian and The Times and Der Spiegel, first published the Manning leaks from WikiLeaks, many of those documents were of real interest to the ACLU. We gathered a bunch of them that were of particular interest related to the CIA's rendition program and Guantanamo and other issues. And then for a lark, I thought, why don't I bring a Freedom of Information Act lawsuit to get these documents that I already have? How will they respond to this? Option one is they ignore the fact that we already have them and just don't give them. Option two is they turn them over in recognition that we already have them. And option three, which struck me as least likely, is they give us redacted versions, redacting what they think should be classified. And they chose option three, even though they were in fact signaling to the world what they considered to be the most important aspects of those documents. Again, for them, their authority to make those distinctions was more important than what the public actually knew.
Okay, but actually there's an interesting underlying question here, which is, let's supposing we give you, Ben Wizner, total power over everything that happens in the United States. Who should be responsible for deciding what is officially secret? So let's start with who can't be totally responsible for it. And I think we'll end up, I will signal this, in a place that's not so different from where we are right now. Of course, the most superficially appealing answer is that our elected officials, by virtue of having been chosen by the public, have the legitimacy to make these decisions. But of course, you scratch that and you realize how circular it is. Because if the president has the authority to decide what information I have by which to judge him, and the president can conceal any unfavorable information, and then by virtue of that concealing gets reelected, how can we say in good conscience that he has been chosen to make these distinctions? So it can't be that it is the executive branch of the government alone that gets to decide what the public gets to know about the most important issues. Is it every single individual who works for one of these agencies? Is it every 29-year-old Edward Snowden who should decide? Well, even Snowden didn't think that. Remember, he could have very easily put this material on the internet himself with less risk and probably not been caught. But what he decided was,
this is what journalism is for, right? This is why journalism is expressly mentioned and protected in the First Amendment of our Constitution. Why we call it the fourth estate. We have 3 branches of government plus the fourth estate of journalism. Let's hand it over to journalists and let them do what they do, which is hammer out in conversations with governments what would be in the public interest to publish and what should be withheld because on balance, it would cause more harm than good. Now, of course, it's easy to say, publish what's in the public interest and withhold what will harm the country's security, when, of course, the same publication can do both of those things. There's no question that publishing the Abu Ghraib photos caused grave harm to the U.S. standing in the world and probably put soldiers in harm's way. And there's also no question that it was vitally important for the public to know that information. But where I land is that the least worst option. There's no one who alone should have this authority. It needs to be some kind of negotiation. And the role of independent journalists is to, in effect, try to challenge the government's monopoly on that decision, try to pry away important secrets in the public interest, and make sure responsibly that the public has access to those. And in the US alone, in the last 20 years, of course, we wouldn't have known about the Bush administration's torture regime, about its secret prisons, about the harms of its drone strikes, about its mass surveillance, if not for people on the inside sharing that information with journalists.
Yeah. You see, I agree with your first premise. You can't trust governments to make these decisions because they have a self-interest in secrecy. And I would say always and everywhere, governments overclassify information. And even if you look at the limited territory of national security, the Snowden material is interesting because they came at us in propaganda terms, waving the stick of organized crime and terrorism and pedophilia, and that's what we're trying to do, and you're getting in the way. But actually, the first 2 stories we ran based on this material were about how they had used this technology at meetings of first the Commonwealth heads of government in the UK, and then a G20 summit meeting in the UK. And they were all over the visiting politicians and their officials, not because of anything to do with organized crime, terrorism, or pedophilia, but because they wanted to know what cards they were holding. It was going to make the negotiation easier. Now, so even on their definitions of national security, they're being extremely misleading about what is going on. Okay. But if you get right down to the root of the argument on the thing that most upset us, the bulk collection of all these phone calls and all this internet traffic, and then sifting through it, your phone call to your partner or to your parents or whatever, I'm not sure how strong our position is. So they say we gather everything, and when we look through it, we're just looking for the pedophile or the organized criminal or the terrorist. So you don't have to worry. We're not actually going to look at anything of yours unless it throws up in that connection. Would we be right to try and stop that happening?
Well, so the first thing I can say is the debate about that harms no one. So when we're talking about what should the public know, who should decide, we couldn't even have that debate because they had taken upon themselves not just to develop and implement a system of mass surveillance, but to hide it from the public and affirmatively to lie to the public and to say that they weren't doing it. So if we're in that conversation, which is about transparency and democracy and not surveillance, I think the answer is really easy. These are questions that should be brought to the public for debate because they're very consequential, and they would have a fair amount of public support for that position. Let us collect it all, and we'll just put it over here, and don't you worry about it at all. Of course, the history of government collection of information and surveillance, teaches us that we shouldn't take a snapshot of what they're doing today to evaluate its danger. We should look at the kind of mission creep that often is, virtually always, is associated with these programs, and then imagine where it's going to go next. So after 9/11, the big complaint of the U.S. security state was there's this terrible wall that is separating information that's collected for law enforcement purposes and information that's collected for intelligence purposes. And it's easy for us to get this intelligence information, but so hard for us to get the law enforcement information. We have to go through all these hoops. And can we just tear down this wall because it's too siloed? The same thing will happen with these kinds of mass collection programs. Right now, they say, don't worry. We're not using any of this against you. This is really just about terrorism. It's just about serious national security issues. But once you collect all the dots, once you collect everything, and the dots will always connect in hindsight. So the next time there is any kind of catastrophe, it doesn't even have to be on the scale of 9/11. It will turn out that the information that could have prevented that with 2020 hindsight was sitting in our databases, and they will say all of these restrictions on what we're able to get are what prevented us from stopping this attack. And before long, every police officer on the beat who's carrying one of these will have access to that information, to that database. They will tear down the barriers and the walls and the lock boxes. And that really is a different world. And maybe people don't experience that viscerally when we're talking about telephone metadata. Over Baltimore, there is a spy plane with an Argus camera that captures 90% of the city in granular detail. And the argument of the Baltimore Police Department is, don't worry, we won't look at it until there's a crime. But do we really want to live in a world where those cameras are in our skies and in our bedrooms and in our phones and are capturing everything just in case and creating what is in effect a surveillance time machine that can be rewound against any of us at any time? That is the debate that the public should be having.
Yeah, and both in the US and in the UK, we know now in retrospect that there was a phase following all the political turmoil of the late 1960s, where in both countries there was what I would describe as extravagant infiltration of and surveillance of left-wing groups. And I mean, including some grotesque violence that was inflicted on some, particularly in the United States. So insofar as you can see that happening with the old-fashioned technology of surveillance, the dangers that are connected here, I think, are huge. I'll tell you a small thing that in the UK, the agency which has a track record of most worrying progressive people who may be the objects of state surveillance is the Domestic Security Agency, MI5. When we were publishing the Snowden material, I had a quiet meeting with a good source who was very familiar with the way that GCHQ were operating. And he told me that in sort of 2008-9, as this huge bulk surveillance operation started at GCHQ, there was a lot of internal debate about whether this was trampling people's privacy and human rights. And the people who were most worried about it were MI5. And you have to push things a long way out to the extreme before MI5 start worrying about your human rights and your privacy. But there it was. Should we switch now to thinking about Ed Snowden's position since the disclosure? Talk to us about what his problems are and what the potential solutions are.
Well, I think I know how this will be resolved, but I don't know when. And what I mean by that is that, in 1971, where Daniel Ellsberg first emerged as the Pentagon Papers whistleblower, what was said about him by the security state will sound familiar to those who have heard Snowden described by British publications or right-wing papers or by members of Congress in the US. He was a traitor. He was a spy. He had dropped off the Pentagon Papers at the Soviet embassy. All of this, of course, wasn't true. And, some decades later, I was debating the Snowden case with a former CIA director, James Woolsey. And even he referred to Ellsberg as a hero. So maybe we won't have a former CIA director referring to Snowden as a hero 40 years from now. But we've already had an attorney general saying that what he did benefited the public, a president saying that he made us stronger. Very little evidence now, 7 years on, 8 years on almost, that anything that he did caused any harm. His emergence as a really an important global human rights figure. And I hope that you and some people who are watching this can take the time to read his memoir, Permanent Record, which is just a absolute testament to what he stands for. And also, very interesting about his life. So, what I do want to make sure people understand is that while no one would choose exile, now he has a baby son, and between exile and COVID, he hasn't been able to be with family other than his wife. No one would choose exile, but he's not asking for any sympathy. This is someone who had every expectation that he would be in prison. And instead, he has had years in which he's been able to participate fully in the debate that he helped launch, to testify before parliaments, to write and speak, to tweet more than I would like him to sometimes. I visit him as often as possible when the borders are open. So he's living a very rich and meaningful life. I want to say that. Now, the charges he's facing couldn't be more serious. Right now, under the Espionage Act of 1917, you commit a felony, as I said earlier, when you provide national defense information to someone who is not authorized to receive it. He has essentially already confessed to that crime. Not essentially, he's done it many, many times. Were he brought back for trial, he'd effectively be being brought back for sentencing, not for trial, because all of the things that you would want to say in your own defense, the journalists who published these stories won the highest awards in journalism around the world. The United States changed its law and policy as a result of this. Court rulings held illegal some of the programs exposed. None of that would be relevant or even admissible in a trial under the Espionage Act. He would not be able to share that information with the court or the jury. So he would be reporting back here to be in a prison cell. So I do want to say that those who say, wow, this great human rights figure is hiding in Russia, sheltered by Putin. Listen, you can question his judgment, but understand that you are saying instead that he should spend decades isolated in a prison cell in the United States. Those are the two options right now, is that he can live where he has his permanent residency now in Russia, or he can live in a supermax prison cell in the United States. If someone offers plan C, and maybe that will happen one of these days, he's very likely to say yes.
So there isn't a legal reply to the espionage prosecution now that he's been so open about his role?
Well, I should say the U.S. Supreme Court has not yet weighed in on whether the Espionage Act can be applied in this way to someone who provides information to the press, but no one seriously doubts how they would decide that question. And every lower court has said that it is essentially a strict liability offense.
But can you see any political way through? And is there any conceivable way in which anybody in the Biden administration might choose to take a different point of view with him?
I don't know. I think what we would be discussing here is not, whether the Biden administration would pardon him or drop the charges, but whether they would allow him to plead to something humane that would not result in long punishment, but would maybe save some face for the intelligence community. Of course, their stated concern is, if he doesn't go to prison for a long time, and he's viewed as a hero around the world, then the next 29-year-old and the next 29-year-old and the next 29-year-old will do the same thing. I mean, I think I understand where they're coming from, but it's a huge gamble. It's very unlikely that the next 29-year-old is going to change the world in such a way that there is this kind of massive public support, where the European Parliament is passing a resolution calling on member states not to extradite the person to the United States. I think there's plenty of deterrent left, even if Snowden, is granted some kind of clemency or leniency. But I think it's going to take some time. I mean, there was a whole storm at the end of the Trump administration about whether he might pardon Snowden and Assange as well. I always thought it was extremely unlikely that he would do it, and the only reason why it was possible is because he's so impulsive and mercurial, and who knows what he's thinking at any given time. But no, look, I think the U.S. intelligence community has a long memory, and I think that it may take a little longer before we can get that resolution in the U.S. Now, the question, and maybe you know this better than I, is will there come a time when some European country says enough is enough, and he's able to quietly move somewhere other than Russia, but not to the United States.
Because the Germans, I think, at one point were sending good signals. And I'd like to just say that I was a reporter for 40 years. I've retired now, but I dealt with a lot of sources in sensitive positions and whistleblowers. And I don't think there was any source who was more straight and honorable than Ed Snowden. And just even, I think, to the point where maybe this was what you were alluding to, he's in a country where the president could snap his fingers and his protection will go. And yet he's used Twitter to draw attention to human rights abuses for which the Russian government appeared to be responsible. I think that's terribly brave.
He tweets footage of ballot stuffing in Russian elections. Yeah. He's always calling attention to street protests. He's attacked Russia's surveillance laws, its anti-gay laws and policies. And I said to him once, are you sure? Right? I mean, I'm not your legal advisor for this kind of behavior. And I'll never forget his answer. He said, I didn't do this to make friends. Well, and he sure made a lot of them, but it's right. He didn't do it to make friends. And for him, it would be unacceptable to live in some kind of forced silence in an autocratic regime after having risked his freedom to point out what were some of the inadequacies of a less autocratic regime.
He's a remarkable guy. Should we have a little bit about the Assange extradition?
I think so.
So shall I kick off, just give you 2 minutes on the UK end?
Yep.
That you'll know that the lower court has ruled in his favour on the very narrow grounds that if he was sent back, his mental health is such that he could be a suicide risk. But they haven't taken his side on the big issues about the application of the Espionage Act. Now, presumably, this is going to be appealed all the way up to our Supreme Court. And I do think there's a chance that the judges up at that level might have the confidence, or we might even say the courage, to smell the political stench around the extradition attempt and throw it out. But there's no guarantee of that happening. So if we take the pessimistic view that he ends up back in the United States, how do you think the courts there would respond to the attempted prosecution?
Well, it's a fair question. It's an unprecedented case, and that's why a lot of the hope of press freedom advocates in the US is that this will be resolved in the UK so that we don't have to find out how the US courts will deal with it, or that the Biden administration and its Department of Justice will make the same decision about this case that the Obama administration did after having a criminal grand jury for several years. They concluded that they couldn't get around what they call the New York Times problem, which is we can't actually fashion charges against Assange that would not also sweep in the kinds of investigative journalism that we want to keep very far away from the criminal law. That's not to say that we know how this will be resolved in the U.S. courts. We don't know, but I want to just sort of point out two major problems with it, one of which I think is discussed a lot, and the other not discussed nearly enough. The first is that investigative journalism is a criminal conspiracy, right?
Oh, really?
What did you do as an investigative journalist? You tried to persuade people to break the law in the public interest. You were conspiring with your sources to get around laws that purported to criminalize the publication of this information, and you were bringing it to the public in the public interest. So saying that Assange conspired with Manning to get this information out is really describing what Bart Gellman does when he has mid-level sources in the Defense Department, right? So there is really, I think it's very difficult, even though some of what Assange did certainly is not common among what journalists would do. Still, when you're trying to distill a principled basis for criminalizing certain publications, it's very hard to do that in a way that doesn't endanger other journalists. And what I mean here is not that the New York Times is going to be prosecuted tomorrow, but that the next time the New York Times is called into the White House to discuss a story, they will have that threat of prosecution over them, and they'll be less bold in how they're dealing with it. I think the second part that has not gotten enough attention is the idea that the U.S. can apply its criminal secrecy laws to a foreign publisher.
Mm-hmm. Go on.
Remember, Assange is not American. WikiLeaks is not a U.S. news organization. And yet we're saying that our Espionage Act criminalizes his decision to publish something that somebody else gave to him. And think about if we try to apply that principle more broadly. Think about if China or Iran decided that their criminal secrecy laws apply to foreign journalists, right? I mean, your paper, the New York Times, are constantly publishing secret documents from those countries. And if you got an extradition request from China or Iran, it would be ridiculed. Is the only distinction that we supposedly have a fair legal system and they have an unfair legal system? Is that the only distinction? Or is it that maybe it's fair game if you get another country's secrets in these things? So I think that, of course, the irony here is that Assange thought that he would be better off in a Trump administration than in the Clinton administration. And now we have this really precedent-breaking prosecution that so far, at least, the Biden administration has not backed down from.
And you're not picking up any hints that they might change their minds at the Department of Justice now and back off?
It was only this week that the new Attorney General was confirmed. So I don't think they were in a position to make those kinds of decisions before they even had their senior personnel in place. We were hoping that they wouldn't appeal the decision of the UK judge against extradition. So far, they have made the decision to appeal that. But I do hope that, depending on how long this takes, and I don't know how long this will take to wend its way through the UK legal system, but that tensions will cool. I think, remember also that the way that Assange is viewed in the US has changed substantially. From even 2014 to now, where he was principally known before for the Manning leaks. He's now principally known for the 2016 election, and that has not endeared him. So he now has enemies on the right and enemies on the left. I shouldn't say right and left. I should say enemies in the Republican Party and enemies in the Democratic Party, and not a lot of friends.
But I think that for the two reasons you outlined, the threat to future US publication of secrets, and secondly, the wider threat to anybody anywhere in the world who tries to expose US secrets in the public interest, it's essential that we all focus simply on the Manning disclosures, which is in its entirety the grounds for attempting to extradite him. And there's a bigger picture there, which I think is really important, which is that when we look at the Snowden disclosures, we're looking at something that's really alarming from the point of view of any civilian and legally very, very gray area. When we're looking at the Manning WikiLeaks disclosures, we're looking at the detailed account of hundreds of crimes committed by US personnel and crimes committed in the Iraqi war logs by Iraqi security personnel and concealed by US forces. Hundreds and hundreds of crimes in detail, including, as a single example, a video recording of a named, identifiable Iraqi major beating up and shooting in the head a manacled prisoner. And not one single one of those crimes has even been investigated or prosecuted or led to a conviction. And that's terribly, terribly wrong. And if you try to call yourself a Department of Justice and do nothing about criminality of that seriousness, and yet come after the whistleblower, it's obviously wrong. I just hope we don't get distracted by 2016 election.
Right. And of course, the advantage that the government or prosecution has in these instances is that they can cherry pick the documents or information that they want to use as the basis of their prosecution. Surely they would not include that. Surely they would not include the helicopter gunships shooting Reuters journalists. Instead, they would choose a sensitive diplomatic cable from the State Department papers. They would choose something that they said maybe put a source in danger, although even in the trial of Manning, they weren't able to produce evidence that anyone was physically harmed by those disclosures. So that is the real challenge, that when you're dealing with a disclosure of that scale, naturally, both sides want to point to the documents that make their case. But of course, the way this is measured is so incredibly unfair. In a world where probably 90% of what is classified should not be classified, the whistleblower is not allowed to make a single mistake. And we only are allowed to analyze the harms from disclosure. We're not allowed to analyze the harms from concealment. And there are real harms to democracy and even to security from the amount of information that is withheld from the public.
Okay. I mean, it's going to take a year or two, I think, for the Assange issue to be settled on the side of the ocean. Okay. Shall we stop there, or is there anything else that you would like to add?
It's been a great pleasure to have this conversation with you, and I hope we'll be able to do it again before too long.
Okay. Thank you for your time, and good luck with Ed Snowden. He's a good man who deserves a good result.
Thanks very much, Nick.